Okay, this is getting a long time, but we got to get this done. This is part 5, reading from a transcript for the trust contest, case number RP 221-20163, Alameda County Probate Court, case of a cancer patient who died, Rabbi Yehuda Ferris of Chabad of the East Bay. Didn't give the siblings any money and is making up this big bizarre story about how he gave them, offered them $30,000. If you asked them for a shred of evidence, they wouldn't have it. Okay, it's just fabrication. Okay, so it says, based on this, so the guys who brought the lawsuit, he says, told there would be an honest settlement for my sisters and I. He did mention how he sought it out in the trust that he drafted that the daughters would not get the entire house, but that the girlfriend, Salgado, the mother of the daughters, was adamant that he did. So he told me that he made a settlement agreement in a subtle way as to convince the mother of the cancer patient's daughter, the Filipino woman, not Jewish, daughters are not Jewish, they never converted, the mother daughters, the other owner of the house, that she would be willing to settle if they got everything. But Rogers, the attorney, said he would manipulated the trust agreement, and he pointed out the settlement agreement. I have it here. It says, if I could go to the settlement agreement that's mentioned in the trust, it says in both trusts. Is it in evidence? Excuse me. Is it an exhibit? Yes, it was. I found it in. Rogers' wife handed me a binder last week. What number is it? Do you know the number? The trust? No, the settlement agreement. The settlement agreement is 51. All right, so we're looking at exhibit 51, said the judge, which has not been admitted into evidence. Okay, on page 3, and each of these has Rogers' signature, I'd like to inform the court that is mentioned in the trust. It says, and I know it by heart, I could read it, but it says the majority portion of the trust, and I assume that is 50.1% of the property, which was delegated to the daughters, Maxine and Flora Ziprin, is dependent. The majority portion of the trust is dependent on a certain settlement agreement, and it names the case number, Salgado versus Ziprin. It was a lawsuit that enabled my brother to obtain possession of the property in the last year of his life. So on page 3, section B, I would just like to read the paragraph. Salgado, that's the mother of the children, the other owner of the house, warrants that she will have prepared and executed, okay, it doesn't say execute. It says, sounds like grammatical. I'm reading word for word. Execute a will or a trust in which she lives 50% of her ownership of the property to the parties' 2 daughters, Maxine and Flora Ziprin, in equal shares with the reservations that Ziprin shall have the right to occupy as long as he is able to reside and pay the expenses of the property. Salgado shall not revoke or modify her will or trust to eliminate the foregoing provisions. So this is key right here. Ziprin warrants to Salgado that he will have prepared and executed a will or a trust which leaves a majority of his 50% ownership in the property to his 2 daughters in equal shares with the reservation that upon his death, Salgado shall have the right to occupy. He will prepare which he leaves a majority portion, a majority of his 50%. That's not the entire. She says that she'll leave her, execute a will which he leaves 50% ownership in the property to the parties' 2 daughters. But he says he warrants that he will have prepared to execute a will that leaves a majority of his 50% ownership of property to the daughters. 2 different things. But what did they do? They sold everything to them for $80,000. They shorted the kids, got nothing, and they lied. Upon his death, she shall have the right to occupy as long as she's able to reside and pay the expenses on the property. As long as the settlement agreement is carried out correctly. It hasn't been carried out correctly because they did exactly the opposite. They gave him the whole half. Check the title. Shall not revoke or modify his will to trust to eliminate the foregoing provision. So here it is. She gives her half of the house to the daughters upon her death, and he gives a majority portion of his half. And the trust says August 26, majority portion of the property, which is 50.1%, to the daughters, is dependent on the settlement agreement. So I'd like to address the narration from Rogers. So Roger portrays me as not accepting a $30,000 offer and being greedy and thinking I own the house. I was living at the house. COVID shut down the entire world. At that point, I got a call from Rogers, and leaving early 22. He says the daughter's putting up $70,000, but I got to get out in 2 months. And I said, oh, I remember this day clear as a bell. Mr. Rogers hold on. I was going to object for the record because this comes into confidential settlement discussions, and it's outside the scope of the case. Outside the scope of the case, and Mr. Margulies, he was claiming, may I talk? No. So Mr. Margulies, this is the opening statement. This is what you're supposed to tell the court the evidence will show. You can't refer to evidence that isn't admissible, and the objection in this is the settlement negotiations, which are not admissible. Okay, may I ask the court a question? Sure. was telling a story. He was saying that I didn't accept an offer, and I wanted to say that the offer was never made. So I don't know how that. I mean, you're the judge. I'm not an attorney. So is that appropriate? He said I accepted an offer, and I said I didn't. There was no offer ever made. So what the court looks at in this information is that's in the evidence. Is this is simply your purview of what the evidence will show? You can't really talk about something that's not going to come into evidence, because I think Rogers was giving the court some of his flavor of the case, and I wanted to basically paint a picture. And I understand that you disagree with that picture. And the court is also aware that the trust document says, and the trust document to the court's regulation gives you $30,000. So your opening statement should be giving the court information about that evidence that you have to contest the trust document itself. In other words, your evidence of lack of capacity and undue influence. So tell the court. My sister Zia Zipper, who I don't see here on the Zoom, I don't know if she's allowed. I see my sister here. Your sister's here. Okay, hi. Just recently, within the last month, she notified me that she had discovered a voicemail of our brother from a long time ago, and I asked her to send it to me, and she did. And I offered to send it to opposing counsel as we went over on Friday, and they declined, and the court instructed me to forward it to them, which I did, and Rogers confirmed that he obtained it. So in that tape, my brother mentions his dissatisfaction with his daughters, and he hadn't seen them. Hold on. The objection is, he appears to be testifying about the context of the voicemail. It's not admitted into evidence, and I have objections to the voicemail. It's hearsay, out-of-court statement. He presented it for the truth of the matter asserted in the recorded document. I don't believe there's a transcript that was ever provided either, which was also discussed in the pretrial conference. And so the objection is sustained. But Mr. Margulies, can you tell the court is that you have a voicemail that you are going to offer into evidence that will support your lack of capacity argument? Is that what you're telling me? Yes. And okay, and undue influence. So there's a voicemail that you are going to offer into evidence, and we're going to see, and we know that there's going to be an objection. All right, so what do you have in regard to capacity? Is there any medical documentation? Okay, that's what the judge asked, and the guy says it was non-admissible without a whole bunch of custodian of records. Right. So yes, I have 2 CDs of about 10,000 pages of medical records, but I don't have the resources to make it admissible. And I do not see any medical providers. Right. I plan to testify. All right. So what else do you have in regards to undue influence other than voicemail? I have my testimony. Okay. I have letters from Maxine. I would like to read the court some things about the definition of undue influence. The legal definition? No, I mean, that's too narrow an angle. I'd like to share with you the court some things regarding what is considered undue influence. Okay. May I? Go ahead. Give me a second here. Bear with me here. I don't have fancy binders like everybody else. I got most of it. I'm just missing one page. So, Mr. Margulies, it would probably be helpful to the court have a legal definition from the welfare institutions, and this is what you have to follow. Okay, I think this is applicable. Are you aware of that? Just the code? Welfare institutions is like one sentence, something. Yes. You have that? Yes. It's more than one sentence. Well, it's on 2 pages. I have that here. The court says, okay, what the court has to follow. Hold on here. It says that the recent laws contained in California Welfare and Institutions Code addresses financial abuse of an elder or dependent adult. In 2009, that section and others of the Welfare Code were amended. The term undue influence was added to section of the California Institution Code. Now states that financial abuse of an elder or dependent adult becomes when a person or an entity does any of the following: takes, secretes, appropriates, obtains, retains, or assists in taking, secreting adult. Your Honor, I have an objection, said the terrorist. At the pretrial conference, we disposed of the issue of elder abuse. So that issue for today are competency and undue influence. What a shyster. Not elder abuse. Excuse me?